SJC-13140, Commonwealth v. Devin, J. Roma.
Okay, Attorney Powell.
Thank you, Madam Chief Justice, and may it please the court. Andrew Power for defendant Devin Roman. Now, this case is about the right to a defendant-capped plea, a right that this court construed in the case of Charbonneau back in 2016. And I want to draw on the following four conclusions from that case. First, a defendant-capped plea protects the defendant from the risk of a higher sentence. The sentencing protections are inherent in a defendant-capped plea. Defendant-capped plea is an essential and unconditional right in district court. And finally, a defendant-capped plea is substantially more protective than a Commonwealth capped plea. So in light of that decision, the issue here is whether there is a compelling governmental interest for withholding those sentencing protections from defendants in superior court where the sentences are the longest and those protections are needed the most. I'll begin with the text of the rule, which is the provision that's being challenged here. It is Rule 12C4A of the Rules of Criminal Procedure. Now, of course, the rules of procedure have the force of law and may not be disregarded by the judge. Rule 12C4A applies to pleas with no agreement as to sentence. Each party has the opportunity to request a sentence. Each party essentially submits a bid to the judge. In district court, the defendant has a right to withdraw.
Counsel, I apologize for interrupting you. I'm curious, though, in light of the short time we have, whether you're arguing strict scrutiny or rational basis, because you're saying that there is no legitimate government interest, and that sounds like rational basis.
I'm using the rational basis standard as a baseline because I don't think it could survive under either strict scrutiny or rational basis, but I am arguing that strict scrutiny applies for several reasons. I could go through those if you'd like to hear them. Let me do that. Strict scrutiny applies because there are several fundamental constitutional rights that are implicated in the differential between defendant capped pleas and Commonwealth capped pleas. The first of those clearly is the right to trial. In district court, a defendant may invoke his or her right to trial if the judge exceeds the sentencing request. In superior court, a defendant may not invoke the right to trial if the judge exceeds that sentencing request.
So it seems like the differential is the defendant cap versus Commonwealth, not the right to trial.
But the differential is the number. So let me give you an illustration in this case.
Well, I understand the difference between the defendant capped and a Commonwealth capped or prosecution capped plea. You're saying strict scrutiny applies because it implicates the right to trial, and I'm saying not really. There's still a right to trial, and it's just the difference between defendant capped and Commonwealth capped.
Well, in practical sense, the defendant is going there to waive his or her right to trial. And under a Commonwealth cap, the defendant may not withdraw his plea if the judge's sentence is below the Commonwealth's cap.
Right. Well,
His
that's
cap.
because, I don't mean to interrupt you. I'm sorry. Go ahead. But just why do you think the legislature didn't pass the same statute for Superior Court?
I believe in the early 90s, when they passed that statute, that they were addressing problems in the district court trial de novo system. And I think Charbonneau explains that they were looking to compensate defendants for the loss of trial de novo in district court by giving them this statutory
And
right.
so why isn't that a legitimate government interest? We're taking something away, we're going to give something back.
That is a legitimate government interest. but
Okay.
That is not a
So if it's a
legitimate.
legitimate government interest, then why is the way that they decided to do it not rationally related to that interest?
Because the statute is silent on whether it applies in Superior Court. So it is not necessarily the case that the legislature intended to deprive Superior Court defendants of this right once created. So they created a right to a defendant cap plea.
Was there a trial de novo right in Superior Court?
No. but
Okay.
We can analogize this to the quaff disposition. The quaff disposition appears in Section 18. It appears as applicable in district court. But this court in Commonwealth versus Powell determined that the quaff disposition does apply in Superior Court so long as it's not ruled out by statute. So in that case, they determined that the statute is silent on quaff dispositions, so those dispositions may be extended to defendants in Superior Court where applicable. And I'd also say that the rule of the canon of constitutional avoidance applies here. So that the statutory text is silent. Therefore, this court should avoid an interpretation that raises serious constitutional doubts, such as equal protection concerns. Codification of the right to a defendant cap plea in district court does not equate with denial of that right in Superior Court. They could extend the right to district court defendants without denying it to Superior Court defendants.
But is that the test under rational basis? That they could do something better?
The test is that under strict scrutiny is that it infringes on several fundamental and constitutional rights. First of all, the right to trial. Second of all, the right to liberty, because a defendant cap plea, as this court has found, offers defendants sentencing protections from higher sentences. A Commonwealth cap, conversely, exposes defendants to the risk of a higher sentence. Therefore, there's a deprivation of liberty in the difference between the Commonwealth cap and the defendant cap because of the.
Can I ask you the practical connotations of this? If someone's charged with trafficking in a controlled substance, right, and they reach an agreement and it's reduced to possession with intent to distribute, and then the defendant essentially does a Superior Court green sheet, which will, right, a defendant cap plea, doesn't it incentivize the prosecution not to reduce charges?
Does the unagreed plea incentivize a prosecution not to reduce charges?
Right.
Well, I don't believe it would, because the prosecutor has the power to reduce the charges or not to reduce the charges. The unagreed plea is available as it is now. So the prosecutor in Superior Court, if he wanted to go forward and not reduce charges, would have the benefit of the Commonwealth capped plea. So I'd say a defendant cap plea would incentivize the Commonwealth to negotiate with the defendant in Superior Court, where the Commonwealth cap plea, the prosecutor may just sit back and allow the defendant to tender an unagreed plea without reducing charges.
Well, it wouldn't work that way because it'd be no partial no plus. But let me ask you another one as far as trying to get behind the rationale here. So you got a disorderly conduct case in the district court, and there's a defendant cap plea, and the Commonwealth is preparing for trial, and the case resolves in a defendant cap plea. Isn't that dramatically different than a complex motor vehicle homicide case with victim and you also might have a lot of witnesses, including experts, and the defendant can just, every time the case is on, despite how much work goes into putting that case together, do a defendant cap plea, and if he or she doesn't like the resolution, wait till the next rotation in the Superior Court and give it another try. And meanwhile, maybe on the trial date, after everything that's gone into preparing this case, the case resolves in a way quite inconsistent with other dispositions that were offered, and quite inconsistent with the Commonwealth's recommendation. Aren't those type of concerns reasonable concerns that are rational?
I don't believe so, because I don't believe it's legitimate to discriminate against a class of defendants merely because they're charged with more serious crimes. The presumption of innocence dictates that criminal charges are not to be regarded as incriminating or creating unfavorable impressions against defendants. So if the right is extended to defendants of lower level offenses, it should also be extended to those defendants who are charged with more serious crimes, because it's simply a charge.
That's but we're talking about a constitutional base, right? A rational basis for that. Did Justice Lowy just articulate a rational basis for the distinction?
No, Your Honor, as I said, it's not rational to discriminate against defendants based on the charges against them when talking
Okay.
about.
What about, there are other things that are different in district court and superior court, such as how a charge comes. Would we have the same argument? Would you have the same argument available to argue that a defendant in the district court should have had an indictment rather than a complaint?
Well, that's an interesting distinction because the charges are brought, again, differently in district court and superior court.
Right.
And trials are tried differently in district court and
That's right.
superior court. Precisely because superior court defendants face more serious sentences.
That's right. So, but why shouldn't a district court defendant get the benefit that a superior court defendant gets of an indictment? I don't understand why the argument doesn't flow both directions.
Because it's inconsistent with the statutory scheme to give district court defendants greater procedural protections than superior
Oh, I
court
see.
defendants, because superior court defendants are charged with more serious crimes, facing more serious sentences, and up and down,
So,
they're getting indictments instead of complaints. Jury
right,
trial, jury by 12 instead of jury by 6.
right. So why doesn't what you've just told me?
Because there's no rational basis for withholding
Okay.
procedural protections from the defendants who need them the most. According to this statutory scheme, superior court defendants receive the procedural protections, the highest level of procedural protection, as opposed to district.
Well,
court
can't you, couldn't one articulate a reason for that for the difference in the plea, defendant cap versus Commonwealth capped plea as follows? It is more likely that a superior court defendant will have the ability for a plea bargain if it's the Commonwealth capped. That is the Commonwealth more likely to agree to a plea if they control, in some sense, the sentencing?
I don't think there's evidence for that. The
Well, not
Commonwealth,
evidence. I'm just thinking about any rational basis for that.
but there has to be a basis in fact or in some sort of evidence. And it appears that if they are looking to resolve cases, at least anecdotal evidence shows that defendant cap pleas resolve cases more efficiently than Commonwealth cap pleas, because the defendant has the power to waive the plea, to waive the right to trial. The judge has the power to sentence. The judge has the power to accept or reject the plea. So direct dialogue between the judge and the defendant as to what potential sentence the judge would be willing to accept is more efficient than going through this back and forth with the Commonwealth. The Commonwealth may be standing back and letting the defendant wait and worry for a while. Instead, the defendant can approach the judge as they do in district court, tender the defendant cap plea, and then it can be resolved directly between the defendant and the judge, which is also consistent with the separation of powers. Because the Commonwealth, of course, has the power to negotiate a plea bargain. The Commonwealth has the power to charge, but the judge has the sole power to sentence. The judge has the power to accept or reject the plea, and the defendant has the sole power to go to trial or plead guilty. So it's far more efficient to have a direct negotiation between the defendant and the judge rather than having to go through the Commonwealth.
But that's an efficiency argument. It's not a rational basis argument, is it? I mean, is the rational basis test a function of efficiency? Is that what you're suggesting?
With a rational basis, there has to be an interest, a
Right, it
government
doesn't-
interest
Well,
that outweighs the prejudice to members of the affected class.
no, there has to be a legitimate government interest.
Legitimate government
And the way
interest.
that the government is guarding that interest needs to be rationally related to furthering that interest.
But it also has to transcend the harm to the affected class of defendants.
So implicit in Justice Graziano's hypothetical is probably the practical result of this, which would be the amount of mandatory minimums that would be sought in the grand jury would increase exponentially. Anytime there's a potential habitual offender, 3 strikes, anytime there's a second and subsequent and on and on and on. The Commonwealth is going to try to be able to have some control over the development of its case and when the plea is going to take place. So in addition to other reasons, isn't this really an argument for increasing mandatory minimum commitments?
No, I think the Commonwealth has the same rights to negotiate the plea under either defendant cap pleas or Commonwealth cap pleas. And I think this really comes down to the essential right. A statutory right was created, just as I would analogize this to the right to appeal. If the right to appeal is created, it must be made available to all defendants. An unreasonable distinction should not be created between groups of defendants that make it more difficult for certain classes of defendants to access that right. There are no further questions?
Okay,
I'll
thank
rest on
you.
my brief.
Attorney Baker. Oh, we can't hear him. I think he's talking.
My apologize.
Okay.
Good morning. May it please the court, Assistant District Attorney Lee Baker for the Commonwealth. So I'd like to start out by addressing the rational basis test. And I would emphasize that the standard here is whether there's any reasonably conceivable state of facts that would provide a rational basis for that classification between Superior Court and defendant and district court defendants. And much of opposing counsel's arguments were really public policy arguments about how, in his opinion, it could be done better. But I think that the questions from the court zeroed in on what's a really important issue here, which is just imagine for a moment that it were the case that the defendant capped plea was extended into the Superior Court. I would suggest it would have a significant impact on altering the incentives of the parties. And that's my main argument in the first place for why it's rational to have this distinction, that the defendant capped plea in the district court does a lot to incentivize defendants to enter pleas. In the Superior Court, if that were to be extended, I think it is quite right that it would alter the calculus significantly for the parties. For example, as the court had brought up, there are significant minimum mandatory sentences, sentence enhancements that are at play in the Superior Court that are not at play in the district court. And it would disincentivize a prosecutor from reducing charges as part of an unagreed plea. Because bear in mind that, of course, the Commonwealth could, in fact, make charge concessions in advance of tendering an unagreed plea with a prosecutor capped plea procedure in place. And so to take that away would alter those incentives, and I think would lead to reluctance on the part of Superior Court prosecutors to make those charge concessions. But moving to the real crux of the issue here, whether or not it's correct, as opposing counsel has stated, that it's sort of fundamentally unfair to place someone in jeopardy of a lengthier sentence just by virtue of what court they're in. I would say that that is not something that's anomalous to Rule 12, but is really a structural difference between the district courts and the superior courts. And you see that with crimes for which there is jurisdiction in the district court as well as the superior court, which has original jurisdiction over all matters. There's typically a difference, and the difference is often significant between the length of incarceration that they're subjected to. And in fact, that's true of most of the charges that this particular defendant was charged with in this case. Furthermore, you can see other examples of that. And one really good example of that is a law that this court had occasion to look at under an equal protection analysis not that long ago. And that's General Laws, Chapter 119, Section 74, which limits the prosecution of juveniles in certain cases. And in Commonwealth versus Fernandez, this court looked at an analogous issue of whether or not it violated equal protection to have juveniles aged 14 to 18 exposed to Superior Court prosecution when charged with murder. And that was upheld. And one of the things that was particularly notable in that decision by this court was that the court found that it was a rational basis test that applied, and specifically said that there was no suspect class at issue and no fundamental rights were impinged by the statute, saying that there is the fact that a defendant was tried in the Superior Court did not violate their rights, and that while there are significant differences between Superior Court and District Court prosecution, that nonetheless, it didn't impinge on their right to be free from physical restraint, which is the argument that was being made here. So I think that Fernandez is controlling. I think that the rational basis test is what the court should apply. And I think in applying that it would withstand that level of scrutiny. Finally, I would just note that Charbonneau, of course, dealing with the trial de novo system, what they sought to do there was to preserve a statutory right that had been in place for a long time and which district court practitioners had come to rely on as part of how cases were resolved. Giving the defendant cap plea sort of made up for taking that trial de novo right away. But it in no way suggested that that statutory right had constitutional dimensions or should be extended to the Superior Court.
Counsel, how would you define the legitimate state interest here?
So the legitimate state interest here is in the efficient disposition of cases. And so, you know, there's language from a Supreme Court case that I cite in my brief, noting, you know, the need for that if all cases were to be tried, that it would require a tremendous expenditure of resources to do that. And, you know, I think that that is not only a compelling state interest, but that's an interest that we all share. And of course, you know, one of the most common complaints that one hears from the general public about the criminal justice system more broadly is its inefficiency. And so that efficiency.
And so how is the Commonwealth cap plea really rationally related to the interest in the efficient disposition of cases?
Right. So again, it certainly, the Commonwealth cap plea in the Superior Court does not create as strong an incentive for defendants to tender a plea. But by the time that a case ends up in the Superior Court, it's already been sort of decided by the district attorney's office that this is a more serious matter that requires more serious consideration. And so that sorting out between the two, that line drawing is going to put some people on the opposite side of the line who might have a nearly equal claim to being on the Superior Court side. But nonetheless, making that distinction between district court and Superior Court overall does lead to a more efficient processes of cases.
Okay, any other questions? Thank you so much.
Thank you.